Kia ora koutou. Thanks for joining us today. I'm Lex, an advisor here at Charity Services, and I'm joined by Lisa, one of our analysts. We are co-presenting this webinar today. This webinar is for people who are new to governance, such as new officers or officers of new organisations, and people who want a refresher on the different structures that registered charities might have. Please note, we cannot provide legal advice on the best entity type or the formation of a legal entity. We recommend you seek independent legal advice from a lawyer, community law centre, if you need help with either of these. A little bit of housekeeping before we start. Can you hear us? Make sure your speakers are unmuted and check your internet if you're having trouble hearing us. In the unlikely event that our sound cuts out, we will work through any technical difficulties and aim to be back in touch with you as soon as possible. The webinar is being recorded and we'll send you an email with the recording link and any resources we discuss. We have time at the end for answering questions, so please type your questions into the Q&A box as you think of them. Please note, we won't be able to answer questions specific to your charity. For questions specific to your own charity, please email us at info@charities.govt.nz. So what can you expect from today's webinar? First, we're going to talk about what it means to be a registered charity and explain the term incorporation. Then we'll discuss the most common types of legal structures for charities, including how they differ and why you might choose one over the other. Lastly, we'll discuss how to change your legal structure if needed and go over the steps you'll need to follow. At the end, we'll answer your questions. Remember, you can watch the recording of this webinar at any time. We will email you the links to the webinar recording and any resources we mention.
Before we talk about legal structures and incorporation, it's important to note that having a legal structure is not the same as being a registered charity. To help explain this, we will start with a quick look at what it means to be a registered charity. A registered charity is an organisation, regardless of structure, that has been registered with Charity Services under the Charities Act 2005. When your organisation becomes registered with Charity Services, it means we've assessed and confirmed that it exists exclusively for charitable purposes, as defined in the Charities Act 2005. Once registered, your organisation is added to the Charities Register, which is a public database that anyone can search to find out what charities do. To apply for registration, your organisation must already exist and be operational. That means it must already have a legal structure, and for example, it might be a trust, an incorporated society, or a charitable company. Keep in mind, though, that only organisations can register, not individuals or one person acting alone.
Incorporation is when you create a separate legal entity for an organisation that's separate from the individuals who run it. This means being able to own property and enter into contracts, and the ability for the organisation to continue operating even if the people running it change. Incorporation also means the organisation is legally responsible for things like debt or legal issues, not the people.
It is important to know that being a registered charity doesn't automatically make your organisation a separate legal entity, and it doesn't make your organisation incorporated either.
That's right. Incorporation is something you apply for through the New Zealand Companies Office, not Charity Services.
Now let's talk about the specific structures an organisation could be. Your organisation structure, whether it's a trust, society, or company, is usually chosen when you first create the organisation and will be defined by your rules document. There are 5 types of structures that we will discuss over the next few slides. These are trusts, incorporated charitable trust boards, societies, incorporated societies, and limited liability companies. We will start with trusts, which is the most common structure when creating a charity. They can either be unincorporated or incorporated. A trust can be used to hold assets on trust for a specified beneficiary. They also tend to have fewer people involved than other structures, and the main officers are called trustees. Trustees are accountable to the public with legal and ethical obligations to act in the best interest of their beneficiaries. The trustees have greater control over the organisation's assets and decisions, as well as how they operate, when compared to other structures like societies. Trusts are therefore a good structure if your organisation needs to own and control assets and doesn't have a lot of people involved.
You might consider incorporating your trust if you want it to have its own legal identity. It's called an Incorporated Charitable Trust Board. This enables the organization to own assets and have the power to sign contracts. Incorporation also means that the trust can continue operating even if the trustees change. If you want to incorporate your trust, you'll need to apply to the New Zealand Companies Office under the Charitable Trusts Act 1957. Remember, trust and Incorporated Charitable Trust Board are types of structure and do not automatically mean that an organization is a registered charity. For a charitable trust to also be a registered charity, it must be registered with us at Charity Services.
A society is a type of organization made up of members who join and help run it democratically. When someone becomes a member, they agree to follow the rules set out in the society's constitution or rules document. Not all members are involved in the running of the society day to day. That role usually falls to the governing body called the committee, and the committee is responsible for management and decision making, but the members have a say as to how the society still operates. For example, by voting on who sits on the committee. Societies are often used for clubs or community groups that don't need to own property or other major assets. An unincorporated society is the most basic and informal structure for a charity, and it is often used by new organizations or small groups, like clubs or local play groups, to avoid unnecessary extra administrative work.
Incorporating your society can be helpful if the organization needs to sign contracts or own assets. Sports clubs, community groups, and organizations with a membership base often choose this structure. If your society is unincorporated, the members are personally responsible for any legal issues or debts. Also, unincorporated societies usually cannot own assets or enter into contracts, such as hiring staff or renting property. If you choose to incorporate, you'll also need to follow the rules under the Incorporated Societies Act and any other relevant laws. Please note, the law has recently changed, and the Incorporated Societies Act 2022 has replaced the Incorporated Societies Act 1908. This means you may need to take action right now to update your rules and re-register with the New Zealand Companies Office if you are an incorporated society. This will take time to complete, so you need to start now. Incorporated societies that don't re-register under the new Act before the 5th of April 2026 will cease to exist. If your organization is an incorporated society, please go to societies.govt.nz today for full details and instructions on re-registering with the New Zealand Companies Office. You can also check there to see if you've already made those changes. As this is administered by the New Zealand Companies Office, please contact them directly as soon as possible if you have any questions about the process.
The last legal structure we will talk about is a limited liability company. It's not very common for charities to use this structure, with less than 6% of organisations on the charity register being limited liability companies. Some people choose this structure if they are operating a business to help meet their charitable purpose. If you are not operating a business as part of your exclusively charitable purpose, another structure might be a better choice for your organisation. If you decide to structure your charity as a company, keep in mind that it cannot provide private profit or benefit. And as such, all companies are incorporated, so choosing the structure means your organisation will automatically be incorporated as well.
At this point, you might be wondering, can I change my organization structure? And the answer to that is yes, you can. No matter what structure your charity currently has, you can change it. However, the process is going to vary depending on your organization. The first step is to review your rules document. This document outlines how decisions are made and the steps to follow when making changes. If your organization is incorporated or planning to become incorporated, your next step is to check with the New Zealand Companies Office and follow their process. Once you've made the changes through the New Zealand Companies Office, you'll need to inform us, Charity Services, about it so that we can update your details. The easiest way to do this is by logging into your dashboard on our website, charities.govt.nz, and submitting an update form. One important thing to remember is that trusts, societies, and companies are governed differently. So if your organization is changing from one legal structure to another, you'll need to create a whole new set of rules. Those new rules must follow the Charities Act 2005, as well as any other rules that apply. Now let's recap what we talked about today. We defined incorporation,
which is an incorporation is done with the New Zealand Companies Office. It makes your organisation a separate legal entity that can own assets and enter into contracts. Remember, incorporation is different from registering with charity services.
We talked about trusts.
These can be incorporated or unincorporated. Trusts are for people owning and controlling property with a small number of people in charge. They are ideal for organizations that need to manage assets with a consistent group of decision makers.
We talked about societies.
And these can be incorporated or also unincorporated. Societies have a membership and are governed democratically, making them great for large organizations with changing members.
And we talked about companies.
Limited liability companies are always incorporated and are usually only suitable if you are running a business.
We also discussed how you can change your structure and the steps you need to take depending on your situation. Before we get to the question and answer section, we're going to highlight some great resources. The first place to start will always be your existing rules. So if your organization already exists and you want to change the structure, start by reviewing your current rules document. This outlines the process for making decisions and changes for your organization. If your existing organization is incorporated, or if you're considering incorporation, then your next step is to check with the New Zealand Companies Office to find out what they require. If you're starting a new charity, visit the Starting Up page on our website. That offers helpful tips, useful links, and examples of model rules for different structures. You can use these to create, review, or update your rules. We also recommend CommunityNet Aotearoa, which provides excellent step-by-step guides on governance. Now we have some time for your questions. Please type your questions into the Q&A box if you haven't done so already. We'll do our best to answer as many questions as we can. We just ask that you don't send questions specific to your charity. If you have specific questions, please send us an email or give us a call. Our contact information is on the slide. Okay, first question. Is a trust and a charitable trust board different entities or terms used interchangeably? Or is the charitable trust board the board of a trust?
So they're not used interchangeably. A charitable trust board is specifically an incorporated trust under the 1957 Charitable Trust Act. A trust is basically just a private trust, and that has named beneficiaries. The main difference being is that the trust has to have the named beneficiaries. However, once you're incorporated, there are specific legal duties because the beneficiaries are public as opposed to named. So even though people do use them colloquially interchangeably, they don't actually mean the same thing. And there really isn't such a thing as an unincorporated charitable trust. It is a registered charity that is also a trust, or a registered charity that is also a charitable trust.
Please repeat where you check if your charity has re-registered. I can take this one.
Yeah.
Yep. So the re-registration we're talking about is, again, specifically for incorporated societies. And where you want to check is societies.govt.nz. That's going to take you to the Societies Register. That's the register at the New Zealand Companies Office, where they list all of the incorporated societies on their register. Put your organization's name in. When it comes up, click on the information. It'll tell you whether you're incorporated under the 1908 Act or the 2022 Act. You want to be incorporated at this point under the 2022 Act. If it still says 1908, you'll need to start that process for re-registration, in which case the same exact website, societies.govt.nz. There is an article right at the top of the page about the process and everything you need to know. Next question is, how do I check if we're already registered as an incorporated organization? Same exact thing, it just depends on your structure. Societies, like I mentioned, societies.govt.nz. If you're a trust or a company, when you go to the New Zealand Companies Office website, there's a button right at the top that says All Registers. Click on that and select the register that would be correct for your organization. If you're a company, select companies. If you're a trust, click Charitable Trust. Put in your organization's legal name, and it will come up with your details if you're incorporated. Next question. A local council says they'll only give a community grant to a registered incorporated society, not a registered charitable trust. Can they demand that or not?
Well, I would say that there's very specific legal question, so I can't necessarily give that specific answer. However, I will say the local council has their own set of rules and bylaws, and they can decide how grants are given out. They can be grants specifically to charitable trusts and to incorporated societies. They can demand that because they are governed by two different forms of legislation, so the Incorporated Societies Act and the Charitable Trust Act, and they have different forms of protection, different forms of transparency and public accountability. So if the local council has specific rules stating that there needs to be this element of transparency, conflict of interest, requirements, whatever that is specifically to your council, they can decide and say it's only for incorporated societies. If the charitable trust can potentially match the same requirements as what the local council is saying, that could be potentially put forward. However, that is on the discretion of each of the local council in each area.
One thing I often advise people anytime it comes to funds is if you have any question about the requirements for a fund, your first place to talk to is always going to be the funder themselves, because they're the ones who are administering it.
Yes.
Next question. Our trust is unincorporated. Why would we want to incorporate? Do you want to take this one?
Yeah, I mean, if you're an unincorporated trust that is already a registered charity, there may not be a necessary reason for you to do so unless you're wanting to gain and hold property, as we said before, and have those asset differences, because the Charitable Trust and Corporation Act, it will create certain obligations and requirements that the trustees will have to do in order to have the benefit of owning that property or being able to make larger fund transactions. So if you're already a registered charity and you're functioning completely fine, really there is no need. However, if you are looking to become registered, there is a significant difference in the legal protections provided by a charitable trust, as I said, because it's governed by a piece of legislation, as opposed to just a trust, which is on the basis of a trust deed, similar to an unincorporated society.
Fair enough. Do changes to the structure need to be overseen by a lawyer?
Not necessarily. We always say seek independent legal advice, especially if you're going to be doing significant changes. Again, it is dependent on your structure though. If it is an incorporated society, for instance, you might have to do a democratic voting, decide, how many members have to be part of that. If it's a trust deed and there is significant changes to some of the protections afforded against, private profit, if it's how the trustees can have discretionary powers, if it's anything to do with the charitable purpose, then potentially seek legal advice, because it could affect your charitable status, because we will be looking at that and seeing if you're with those changes, your entity is still able to operate as a charity. So seek legal advice if you feel the need. I don't know.
Yeah. Ultimately, it's not something that's mandatory as part of providing changes to us. But if you have any questions about the changes, we always recommend seeking independent legal advice.
And if they are quite significant or major or will affect how your entity or your charity actually operates, and you don't know what kind of legal effect it will have, then yes, it would, not mandatory, but very helpful.
Can I start my charity activities and receiving donations after incorporated, but not being registered under charity services?
It's actually an offence to call yourself a charity if you are not a registered charity. So you should not be saying that you're doing charitable activities if you have not registered under charity services. You may be doing non-for-profit activity, but to claim charitable status when it has not been granted is not legally compliant.
But you are able to operate prior to applying for registration with us.
Yes, and you actually, to be registered, we have to see proof of being operational, just non-for-profit operations, I guess.
Another thing to consider is if you're receiving donations before you have donee status, I don't know that that's able to be applied retroactively. So if you're receiving donations, I'd probably say seek independent legal advice and talk to Inland Revenue
Yes.
as well. Do we need to do any AGMs for a trust?
I think that's an annual general meeting. I don't necessarily think it is required for the trust as an annual, because that's generally reserved for societies or companies. However, there are meetings generally for the trustees to operate, congregate, and make decisions, but not necessarily unless the trustee specifies that you need an annual general meeting at this many times a year once.
But as part of operating, your trustees are definitely going to be meeting with each other.
Yes.
Yeah. Changing your charity structure from one type of entity to another will require transferring assets, contracts, bank accounts, etc., and could affect donations, bequests, referring to the older entity, not the new one. Do you want to take a stab at this one? Or do you want to see if they can clarify it?
Yeah, I mean, let me just reread there. I transferring assets, could affect donations, referring. Yes, we're referring to the old one because it's already an established charity, right? The entity, let's use it for instance, if you were a trust and you decided to become a company, not that you would do that, but great example because it's shocking. That would affect how you now, because the company has to have very significant private pecuniary profit clauses to do with how they deal with their income. That would affect how the bank, how your assets are moved around, how the contracts will happen. So the trust will be affected. However, it will retroactively, I guess, affect the new entity because you will not be able to operate within the new entity if you haven't done so with the old entity. To clarify though, when you're changing your structure and you let us know, and you know, the drastic thing from a trust to a company is not really tending to happen, but when you're doing that, you can still keep your charity number. So it's not like you're withdrawing your application and re-registering altogether. You're just letting us know that there's been a structural change.
Which is different to the company's office. Yes. Because they will require you to deregister as the old one and re-register as a new one.
Yes. And so, you know, if you're asking, why should I, you know, if it's going to affect all of these things, why even bother to do that? Only if, you know, there's a need to do that. There is a specific,
Sometimes people need to change their structure, and the process can get a little bit muddy. It ultimately depends on your situation. Have a look at your rules, whether or not you're incorporated. Talk to the company's office if you are, to see what they require at each stage. Next question. What's the difference between a trustee, a board of trustees, and board members, and the duties and responsibilities of each of the above?
So a trustee is an individual that has the fiduciary responsibility to, you know, act in the best interest of the beneficiary. They have that authority and that power. So they hold the assets and the funds, and they're acting on behalf, on trust, for the beneficiaries. A board of trustees is the individuals that are all trustees that make up that group of individuals who then come together and collectively decide how to use their discretion. And board members are generally referring to either potentially companies, but more so in incorporated societies or unincorporated societies, because they are, it's not a board of trustees. It's literally just a board of members, the members that have been decided to make up the committee member board. Sometimes it's called board members, committee board, make up those leadership positions and do the delegation powers, how things will be used, how the assets, how the funds will be distributed. However, they have to be more accountable specifically to the members themselves, because they are democratically elected, as opposed to trustees and the board of trustees, because they are just chosen. They're not democratically elected. You got?
Yeah,
do you want to add?
I think that's pretty clear. The only thing I'd say is board members, if you're a society, they're often going to have positions.
Oh, yes.
Trusts and board of trustees, they're most of the time going to have trustees as their position. Board members for societies, they're going to have positions like treasurer, secretary, stuff like that. Let's load up some more questions.
Mm-hmm.
What's the typical time frame to register for one of these structures? I'm leaning towards the incorporated societies. So keep in mind that time frame for charity services is you applying to become registered as a registered charity, which is the same regardless of your structure. If you've got a question about the time frame for incorporation as specific structures, for example, societies or trusts or companies, like we said, that is administered by the New Zealand Companies Office, and they would have those timeframes for you there. What about if we want to change some old trustees that are unreachable now? Where do we go to? Would you say the rules document would be the first place to go to?
Yep. Generally, your rules document will state how you can change trustees. There should be a section literally saying how you change trustees, and what it will generally say if someone is unreachable, if they've not been accounted for this number of days or whatever, then we can follow this process. If it is completely unreachable and your rule document, your trustee says nothing on it, you may have to seek independent legal advice as to how to actually move forward with that, because that is a very specific legal situation and will have specific legal repercussions on the trust if you do just change trustees without letting that person originally know.
Definitely. What are the legal liabilities of the trustees of a charitable trust versus members or board of an incorporated societies?
Sorry, I just put that. Yeah, I can take. Do you want to take what the board members of an incorporated society have to do?
The legal liabilities of a board member?
Yeah.
I'm not sure I know beyond the requirement to meet your obligations under the Incorporated Societies Act, under the Charitable Trust Act, and whatever operations you're doing, such as commercial activity.
Yeah. I mean, realistically, there is a lot of small differences in how, because again, their legislations, they hold the same when it comes to personal liability for the board members and trustees. The liability is the same because there is no personal liability. They have different requirements in what they have to do in the sense of act in the best interest. There might be different reporting standards as to how each entity has to do it. But when it comes to the liabilities of the trustees and the board members themselves, they don't have personal liability because it has now been taken away into that entity themselves.
Next question. Does an incorporation of board of trustees make it easier to administer a trust and protect individual trustees from liability because the board, not the trustees, will enter into contracts and incur obligations?
Yes, you are correct. Let me just pause for a second. I need to. The thing is that the board of trustees and you're not going to have personal liability because the trustees have to act in the best interest unless you're acting with gross negligence, you're misusing the funds, and there is clear misdemeanors. That there are the same form of protections on both parts of the legislation, whether you're an incorporated society or a trustee. I'm not 100% sure what this question is actually trying to clarify. If you have any idea.
I think it might be referring to easier to administer. So it is true that becoming incorporated does, in most cases, shift liability to the organization itself. And yes, one of the main reasons to incorporate is because the organization itself can enter into contracts and incur obligations. Whether or not that makes it easier to administer the organization rather than being unincorporated, I think would ultimately depend on your individual situation. Do you think that's right?
Yeah, definitely. I also need to clarify that if you are a private trust and you are thinking about being registered as a charity, you have to make sure that there are already elements and clauses in place to ensure that there is not going to be that you to some extent the liability is for not liability. You have to be accountable to the public. So it's unless there are very strong protections already set in place as a private trust, it is not the same as being an incorporated trust and applying for charitable status. Just to clarify, there is a difference.
Fair enough. And we have one follow-up question looking for clarification on whether or not you can call yourself a charity without being registered, because their understanding is that when you become registered with us, you get to call yourself a registered charity, because registration with us is optional.
If we're looking for technicalities, yes, but also it is still an offence because the reason why you get the status of a registered charity is because we have ensured that your entity is actually operating for the public benefit. So when entities call themselves charities or claim charitable status without actually getting that registration process, there's no way to ensure that what they are actually doing, from the people that are giving them donations, for the people that are sponsors, there's no way of ensuring that they're actually using it for charitable purposes and for the public benefit. So that's why there's an offence there. You can call yourself a non-for-profit organisation, but to advertise that you were a charity when you are not actually registered as a charity is it's misinforming the public, and that is actually an offence because we can't determine whether or not you actually are using your funds, the donations people are giving you for charitable status. How do we know? We don't know. You've not registered. That is the only reason that so
Next question. Do all decisions made by our trust need to be uploaded to the charity's website? For example, meeting minutes, or is it the only actual documentation required the annual return?
I think you can take that.
I can absolutely take this. So we do not require you to provide us with your meeting minutes. You absolutely need to be taking minutes and keeping your records so that they're available. But when it comes to reporting to charity services, you need to provide us with any updates to your organization's information. So, for example, if a meeting results in a change to your rules document, you need to provide us with the change, but you don't need to provide us with records of the process that led to that change unless you want to. Same thing with annual returns. You don't need to provide us with the record of the meeting where the annual return was approved and signed, but you do need to provide us with the annual return and performance report that goes with it.
Meeting minutes can be used if, for instance, you have nothing else, but you want to be making a change and the meeting minutes are available. They can be used if you want to inform us of a change. But yes, once again, you don't actually have to provide them, but it is definitely necessary to keep them and have them.
Yeah. And when you're adding officers, a lot of you will probably already be aware that there is an option to say, yes, I want to provide supporting information. And that's where you would do so for adding an officer. You could add their meeting minutes or signature to say that they've agreed to join. Similar with adding your rules, you can upload your rules and supporting documentation. Just keep in mind that it's not usually a substitute for the change itself.
Yeah, but you make sure that if any change is provided, all your members, committee members or trustees actually sign the document.
Are incorporated societies obliged to hold AGMs?
I think they are by under the Incorporated Act, because it's an annual general meeting, and because an incorporated society is a democratically elected group of individuals, I think you are obligated to have one at least minimum annual general meeting that has reported meeting minutes as well.
And I believe probably a minimum notice so that people can be made available and go to it.
Yes.
Are incorporated societies required to have trustees, or is a board sufficient?
They don't have trustees. They only have a board. So yes.
Yeah. Societies are made up of members, and those members elect people to be on their governing body. A trust is made up of trustees, and all the trustees are trustees on the trust board.
Yeah. Think about it in the sense that, like, the trust, colloquial word, right? To trust someone that they are going to act in their best interest. These trustees, they're not elected. We assume, we give them the trust that they will act in the best interest, whereas societies, they're elected because, right, societies are democratic and we need to make sure that everyone is represented. So just two different ways to remember it.
And if you consider it in terms of membership, a society is automatically going to be, by default, quite a bit larger than a trust, because you're bringing people in to become members of the society, and then those members are electing a board, and members can leave and come in, change around all the time. So that meeting, that annual general meeting, comes with being a member,
and saying,
talk to the board,
and saying who is now going to be elected. These are the new representatives. That is not common or necessary as much with trusts or trustees.
Because again, all the trustees are part of the trust board.
Yeah.
Do charitable trusts have beneficiaries, or are their objects just their charitable purpose?
Well, they technically have beneficiaries in the sense that it's for the public benefit, and that is the main difference, right? That the charitable trust has their beneficiaries, rather than having named beneficiaries, John, Sally, and Paul, we have for the public benefit. So in a way, their beneficiaries are the object of their charitable purpose, to specifically towards something. However, the charitable purpose is still, alone its own charitable purpose, and it has to be for the public benefit in a separate way under our charities registration.
Are charitable trusts exempt from fringe benefit tax? We unfortunately cannot answer questions about tax benefits because that's administered by Inland Revenue. If you had any questions about tax or tax benefits or the administration of them, always contact Inland Revenue directly. When an amendment to a clause is approved by trustees, what has to be lodged with New Zealand Companies Office and the Charities Register? Is it just the resolution relating to it, or does a copy of the updated trust deed in its entirety need to be lodged?
If the trust deed has been changed significantly, has it got, affected clauses throughout the whole thing, then the whole document, realistically though, if it's only a change, specific clause, one clause, it's that change that needs to be provided, and to just state when you're actually telling us this is the only thing that has changed. Nothing else has changed, because that's what we're looking at. Nothing else has changed. We're just ensuring that your new clause is still compliant, and then we can go, A-OK, you're good to go. So you don't necessarily need to give us the whole thing unless there's significant change throughout the whole trust deed.
Yeah. When you're completing an update details form in our system, and you say that your rules have changed, you can upload just an amendment document, and that'll be uploaded, if it's approved, to the register alongside the existing rules. But you also have the option to say your whole rules have changed and upload that whole new document, and then we'll assess it as a whole change. Next question is, what is the procedure for changing from an incorporated society to a charitable trust? I can take this one if you like. So as we discussed, there are quite a few steps, and ultimately it depends on your organization and your rules. If you already exist and you probably do if you're already an incorporated society, the first step is always going to be look at your rules document. Your rules document is going to say how your organization makes decisions, and it's also going to have a clause about how you make changes. Follow those processes to make a decision and make a change. Because you're incorporated, your second step is going to be contacting the New Zealand Companies Office to find out exactly what process they require for you to change from an incorporated society to an incorporated charitable trust board. Once that process is done and the change has been made to your incorporation and your organization, then what you need to do is tell us that the change has happened. And that's just done by logging into your dashboard. There's a button at the top that says Update Charity Details. If you've changed from a society to a trust, you're going to have probably a new name for your organization. You're going to have different positions for your officers and potentially all new officers. And you're going to have a new rules document. At the least, those three changes are going to happen. Upload the new document, describe what the change is, what's happened, submit the change to us, and that's probably not going to take immediate effect because it's going to need to be reviewed by us to make sure the changes are allowed and allow you to continue to be registered. And then we'll contact you as we process it if there are any questions or when it's processed, if it's okay.
To also clarify, incorporated societies and charitable trusts, they do have different purposes. So incorporated societies, they don't have to be for the public benefit. Charitable trusts under the Incorporation Act do have to be for the public benefit. They do have a wider scope of what is considered to have public benefit than the Charities Act 2005 and what we have to consider, but you won't also automatically get that status as a charitable trust if you don't actually have charitable purposes for the public benefit as stated under the Charitable Trust Act of 1957. So if your society doesn't actually have a purpose that will fit into that, just have a look and be aware of that when you're making any potential changes.
Next question. Do board members on a society have to be members of the entity to be elected, or can they be just a random person who aren't members who have put their names forward? I'm not sure. My assumption would be they have to be members, but ultimately I would say check with your rules document and the New Zealand Companies Office.
If you're part of a society, you're going to be a member anyway. If you're a random person passing on the street, you can't just put your name forward to have some sort of authoritarian or discretionary power on a board society. You have to be a member to be part of that. But you can be a member that has had no kind of authority before and put your name up and say, hey, I'm a member, I haven't really done anything, I'm new, and I'd like to be part of the committee. That you can do, but you have to actually be part of the group to some extent. You can't have no affiliation and then try to have authority unless it's a specific contractual authority, such as a lawyer or accountant or auditing person.
Fair enough. Makes sense. Is it considered a conflict of interest for trustees to also work for the service that it governs?
Work for the service that it governs. If you're gaining some sort of private benefit, then yes, it is it's a conflict of interest. Generally, trusts have you can be remunerated for your services as a trustee, but they have to be reasonable and they have to be at open market value, and you have to actually have reasonable documentation for that remuneration and for the payment of trustees. That doesn't necessarily make it a conflict of interest. What does make it a conflict of interest is if that trustee is working for them for, the service, and then is also voting and making a decision on how much money and remuneration they get for that service. That is a conflict of interest because they should not be making decisions as to how they themselves get paid. That answers that, if that's what it...
I think so. Are registered charitable trusts automatically recognised as a donor organisation for the purpose of allowing donations and bequests?
I don't
That sounds like a question for Inland Revenue. They administer donations and donee status.
We don't administer donee status.
So I would say have a talk to Inland Revenue. Next question. An incorporated society must have a minimum of 10 members. That is under the 2022 Act specifically. But if it's then operated as a charitable trust, do you still need the 10 members minimum? So remember, membership is about being a society. Your society has members. A trust won't have members. But in terms of the minimum number of trustees that an organization needs,
generally it's about 3. I mean, you can, at a very big technicality, have 1 trustee if you are an incorporated charitable trust, but generally it's about 2 to 3 trustees. But members, as I say, a member isn't a committee member in a society. A member is literally just another person in the meeting room who wants to participate and partake.
Yeah.
So a society needs to have at least 10 people interested to partake in that group. But you do not need 10 people minimum to create a trust board. You just need about 2 to 3 people so that it accounts for any conflicts of interests, if there's any, remuneration or payment or anything like that.
Yeah. And you can see immediately that that's one of the core differences between a society and a trust, is that a society is inherently larger than a trust and more democratic because the members get a say, versus the trusts where the trustees decide without external input or voting. Yeah. If an incorporated society calls to re-register members, as the membership list has not been updated for many years, will previously registered members need to be re-registered, or are they still considered registered? This is a question about specifically the Incorporated Societies Act 2022. They have a lot of really, really good information about what constitutes a member and the process you need to follow to get that informed consent for people to agree to become a member. So I would say, to answer your question, contact the Incorporated Societies office directly, because that requirement comes from the Incorporated Societies Act. Yeah, so
we never read that.
Next question. Just clarifying, the required re-registration before the 5th of April 2026 only applies to incorporated societies, not trusts. That is correct. So the different structures are governed by different laws. And the law that governs societies, the Incorporated Societies Act, has recently changed. It changed from the Incorporated Societies Act 1908 to the Incorporated Societies Act 2022. And as such, if you're incorporated under the 1908 Act, you have to take action now to make changes to your rules document and bring it in line with 2022 and re-register that organization with the New Zealand Companies Office as an incorporated society under the 2022 Act.
Not us.
Not Charity Services.
You still retain that issue with us, not with issue.
Yeah, ours is an update after you re-register.
Yes.
We're not requiring you to re-register with us at the moment. The law change has not applied to companies or trusts, because those acts have not changed. It's still the Charitable Trust Act 1957 and the Companies Act. I can't remember the year off the top of my head.
2008.
Yeah.
2000.
So the reason societies need to re-register with the Companies Office is because the law has changed for societies. If you're a trust that is incorporated under the Charitable Trust Act 1957, your incorporation continues. If you're a company, it continues.
If you're unincorporated, it continues, but incorporate if you'd like.
Yeah. If you're unincorporated and you're considering incorporation, you would incorporate under the applicable acts 2022 or 1957, depending on your structure. Next question. I'm already a registered charity with Charity Services. What will the effect be if I want to change my charitable trust's name? Our purpose and activities will remain the same.
Yeah, nothing. You just need to let us know. Do a fun little notice of change. Is it not?
Update details form.
Update
Yep.
details form with us, and just let us know. It is generally if something with its as a name, it is automatic almost. We don't necessarily even have to check it. Unless it is going to be.
We definitely do check it.
We do check it.
It's just a different team to Lisa's team. What we're checking for is whether or not the proposed name is used by any other organization, and if you're incorporated, whether or not the change has already taken effect with the New Zealand Companies Office. Because if you're incorporated, they determine what your legal name is, and the change has to happen with them first. We also check for offensive names. I've personally never come across any, but it is something that we check for. We only have a couple of questions left, so we'll try to answer the remaining ones in the time we have. This question is, where can I find this information written down? Is it considered a conflict of interest for trustees to also work for the service that it governs? We have a page on our website specifically about conflicts of interest.
Yeah.
Sure.
Yeah.
Is there anywhere else?
Well, no, but our website goes into depth into the different types of conflicts of interest and how they are different for each of the different structures. So yeah, just go charity services, conflict of interest.
That's right.
Or otherwise you can message us at infos@charities.government.chairvt.nz with a specific question if you were thinking or wanting to have clarification on something specific.
Yeah. The next question, to change from a charitable incorporated society to a charitable trust, don't you need to set up the new charitable trust, approve and implement the transfer of the assets from the first one to the second one, and then notify the change of structure to charity services, and then wind up and deregister the society? Yes, that's correct. Like I mentioned, if you're an incorporated organization, that second step and fourth step are administered by the New Zealand Companies Office. So I always recommend contacting them directly, because they're going to tell you exactly what your specific organization needs to do. But the first step is setting up the new organization and then notifying us of the change after everything's done. Absolutely. Those are steps you need to take. Is there anything you want to add to that?
No, not particularly.
Okay. Just see if we have any more questions. Just a moment.
Can't read that fast enough.
That's okay. It looks like we have one more question about holding a meeting and establishing a new entity. It looks like it's quite a specific question about your organization's specific situation. I'd recommend emailing us, info@charities.govt.nz, with your organization's details and the specific situation that you have a question about, so we can help you with that. Last question. Regarding the name changing for a charitable trust that's already incorporated, do you recommend starting with the New Zealand Companies Office? I recommend starting with your organization's rules document, because your rules are always going to say specifically for your organization what process you need to take to make a decision and what process you need to take to make a change within your organization. Once you've followed your internal process, then yes, if you're incorporated, you must change your legal name with the New Zealand Companies Office first, because that's where they establish your legal name for your organization. Once that change has happened, then you tell us that the change has happened with an update details form. Again, it's just at the top of the page when you log in, update charity details. The very first field in that form is your organization's legal name. You just edit the text right in there. And then if there are any other changes, you submit it to us. It doesn't take effect immediately because we have to manually check it. But if there are any issues when we're manually checking it, we'll be in touch with you directly. Most of the time when an organization changes their name and we're not able to process it, most of the time it's because they're incorporated and have not changed it with the Companies Office. Thanks everyone for all of your questions. Remember, you can rewatch this webinar again at any time, as the recording will be available on our website. We hope that attending today's session was useful to you, and you now understand more about the different legal structures that charities have. If you weren't able to answer your questions, please contact us by email or phone. Thank you for attending.